Before we go to the next panel, we are very pleased to have a video message from the UN Special Rapporteur on the independence of judges and lawyers. She's based in the US. Unfortunately, she had some very important other commitments, so she could not join us here today. But she has an important message for us, and it is related also to the report that she did on artificial intelligence, promises and pitfalls for justice systems. As a CCBE, we were very pleased. We have a very close contact with the UN Special Rapporteur taking this role, and also with her when she took this role 2 years ago. We have engaged a lot, and among others also on this topic, we also gave the lawyer's perspective. It's the UN Special Rapporteur, so it's a global perspective on digitalisation of justice and the use of AI by courts and lawyers. So we also fed into that, and we are pleased to show you the video message.
Good morning. My name is Margaret Satterthwaite, and I am the UN Special Rapporteur on the independence of judges and lawyers. It's a pleasure to address this timely event at the European Parliament, and I extend my thanks to the CCBE and the European Lawyers Foundation for inviting me to participate. Artificial intelligence and the digitalization of the justice system are issues of fundamental importance to my work as UN Special Rapporteur. You may be aware that as a mandate holder of the UN, I am an independent expert appointed by the Human Rights Council. My mandate tasks me to identify and record attacks on the independence of judges and lawyers, to note progress in enhancing their independence, and to find ways to improve justice systems. So as you can imagine, I am very interested in the ways that AI could be harnessed to improve justice systems, while urging caution about the risks it poses. My activities include presenting 2 annual reports on themes of global significance. Next month, I will present a report to the UN General Assembly on AI in judicial systems. My hope is today to present you with some of the most important conclusions of that report. First, it's important to stress that AI is already being employed by courts, judges, prosecutors, and lawyers, sometimes with official sanction and guidance, and sometimes by individuals on an ad hoc basis. Europe has led the way on regulation, with the first internationally legally binding treaty on AI in the form of the Council of Europe Framework Convention on Artificial Intelligence, as well as landmark legislation in the European Union AI Act. While such general-purpose regimes may provide an overarching framework for the regulation of AI in justice systems, it is vital that judiciaries and lawyers' associations govern their own use of AI. Many self-governing bar associations around the world are already quite advanced in their regulation of AI use by lawyers. But a survey conducted by UNESCO in 2023 revealed that while up to 44% of judicial operators had used AI for work-related activities, only 9% of respondents said that their organization had issued guidelines on the use of AI. One of my aims in the forthcoming report, then, is to provide a roadmap to organizations preparing or refining guidance of this kind. The overarching message of the report is this: as with all technologies, AI use must comply with human rights. Those considering using AI should assess which justice problems it can help solve, whether it is fit for purpose, and when it may actually make things worse. When do the impacts of AI deployment, in particular its environmental impacts, outweigh its benefits? In my report, I examine the impact of AI on numerous human rights within my mandate, then assess how the promise of AI can be harnessed and the associated pitfalls avoided in relation to these rights. I look at 3 rights in particular. First, the right to access to justice. Second, the right to a fair trial. And third, the right to a hearing before an independent and impartial tribunal. Today I'll touch on my primary conclusions in respect of each of these rights. First, AI offers real promise and real potential to reimagine access to justice. AI can extract information about the law and collate and convey it in accessible language and user-friendly formats. Building on this capacity, non-lawyers can use AI as an intermediary to receive queries in plain language, to identify applicable laws, and translate them into a comprehensible format. There's been a proliferation of such AI-powered assistants around the world. In appropriate circumstances, when there is no right to free legal aid and litigants regularly represent themselves, AI might even facilitate interactions with the court system, and the growth of AI tools that assist non-lawyers with the preparation and filing of documents in court may be helpful. AI assistance has certain benefits, after all. It can be accessed 24 hours a day, sometimes via smartphones, often in multiple languages, without users having to travel or navigate often intimidating interactions with court systems. However, the promise of AI is dependent on its capacity to carry out these important tasks with a high level of accuracy. If AI applications summarize or translate a document inaccurately, misinterpret a user's query, identify irrelevant legal rules, or pursue improper avenues for redress, they may do more harm than good. Recent research, for example, has shown that leading legal AI research tools hallucinate some 17 to 33% of the time. Most lawyers would consider this an absolutely unacceptable rate of error if receiving such material from a human junior lawyer. Errors may be reduced, though not entirely avoided, when AI is trained on custom data sets and then subjected to supervised learning and ongoing review by lawyers. But when done properly, this process is expensive and time-consuming, and this work is complicated by the fact that many states lack fully digitized legal databases. This paucity of data may require the allocation of significant resources for identifying, compiling, and digitizing relevant laws, cases, and guidance before effective AI solutions can be developed. Furthermore, offering new paths for filing complaints will be futile if dispute resolution services don't have the capacity to address these complaints. Over-reliance on technological solutions must not lead to the defunding of legal services and existing efforts to close the justice gap, especially since many populations are excluded from digital solutions, and these are often the same populations that have unmet justice needs. Low-tech or no-tech solutions should always be considered before resorting to artificial intelligence. Turning to the second set of rights impacted by AI. AI holds some promise for enhancing fair trial rights and increasing equality before courts. Lawyers know that around the world there are failures to achieve guarantees of due process. AI can support procedural fairness by facilitating translation of legal documents and interpretation at a lower cost. AI might also speed the resolution of court proceedings and appeals through automated case management and transcription. And AI might even be used to support the right to assistance from a lawyer. In a recent field study, 90% of legal aid professionals who were provided with free access to AI products for research and drafting reported increased productivity. AI in no way replaced the need for a human lawyer in this study, but it did reduce the time spent performing lower stakes tasks. And this could arguably be seen as freeing up time for more sophisticated work with clients. This may even allow legal aid lawyers to support more clients, leaving fewer people without representation. However, in practice, the prohibitive costs of specialized legal research tools limits these programs often to big law firms that can afford enterprise-level investments, relegating less wealthy lawyers and their clients to often free or low-cost models that may be less accurate and less effective. This kind of imbalance risks creating a stratified legal system and supercharging inequality between lawyers and litigants. In the worst-case scenario, states may attempt to replace free legal aid with lower-cost AI programs, undermining the right to counsel for poorer litigants. This is unacceptable. Although AI may offer productivity benefits, it must never be used as an excuse to deprioritize funding for legal aid provided by lawyers. Finally, while AI might also be used to enhance the capacity of judges, it also risks interference with their independence and impartiality. Now, judges may use AI in a variety of ways: to summarize legal submissions and evidence, find similarities between cases and offer insights, search for and retrieve relevant legal documents, conduct risk assessments, create initial drafts of opinions or routine orders, and edit, proofread, and check spelling and grammar. But threats to independence and impartiality can come from various sources. The first is inherent to AI systems. The black box nature of these systems means that judges cannot inquire why an AI program favored one option or another. It may have made a good connection, or it may not have. Furthermore, automation bias means that judges may be more inclined to trust algorithms uncritically, which would erode judicial discretion. Even greater concerns arise where AI systems may be intentionally manipulated by governments or private actors to influence judicial decisions in a particular direction. AI could be used, for example, to monitor and pressure judges. And if AI systems make recommendations to judges in such circumstances, they may be required to justify departing from these, further restricting their discretion. Last but not least, we know that biased and discriminatory data, when used to train AI systems, results in supercharged bias and discrimination. This risks having a substantive impact on the quality and impartiality of judicial decisions. But this is also a concern because the risk of bias in AI is well publicized, so the very fact justice systems are using AI can undermine public trust. I'd like to close by stressing that whatever assistance AI might provide to both judges and lawyers, the right to a hearing before an independent and impartial tribunal requires access to a human judge, and the right to counsel of one's choosing entails access to a human lawyer. It is for judiciaries and lawyers' professional associations to decide how best to protect these rights in the face of increasing AI use. With that, I turn back to your deliberations at the European Parliament. I wish you well for your further discussions on how best to balance the many promises and risks of AI for lawyers and the legal profession. Thank you.